All right. Well, hello, everybody, and welcome to today's webinar. Today, we're going to be talking about community property trusts and how they can help save on heavy taxes. My name is Josh Bromley. I am a trust officer for Kodiak Trust Company, and I just started here in Alaska about a month or so ago. I moved up from California, where I had been practicing law, focusing on estate planning, and moved up here to the frigid north from sunny California. So you may be asking, well, why would I do that? And well, that's where we get to Alaska, which has some of the best trust statutes in the country. It's recognized as one of the top jurisdictions in trusts for several reasons, both having to do with taxes, self-settled trusts, asset protection. And we also have a legislator that is very attentive and is very interested in keeping it that way. Here at KTC, we are an independent trust company. We're a more boutique operation focused on giving our clients a great deal of flexibility. We have a great deal of experience working with clients both domestically and internationally. And today we are happy to be joined by two very experienced attorneys, and Peter Myers and Leonard Anderson. Peter is an attorney out of San Francisco Bay Area in California who's very experienced at doing these types of presentations. He's very experienced in estate planning. Leonard Anderson is an attorney out of Alaska, just down the road here in Anchorage, and very experienced as well with almost 30 years practicing in estate planning. So we're very grateful to them for joining us today as our presenters. Before I turn the time over to you guys, just a quick note that at the end of the presentation today, we'll have a time to be for question and answers. So if you have questions during the presentation, please feel free just to enter them into the chat, and we'll keep a log there of questions that we'll answer at the end of the presentation. So without further ado, I'll turn the time over to Peter and Leonard.
Wonderful. Thanks, Josh. And it's great to have Leonard here. I've done this presentation for Kodiak before, with the downside that I'm not licensed in Alaska. So we started getting questions about, well, what about Alaska? I don't know. And I can't help you in Alaska. I'm licensed in California and Nevada. I've done this presentation a lot about Nevada, but Nevada, unlike Alaska, does not have this opt-in regime that we're going to talk about the next slide. Here are the traditional community property states. Traditional, you'll see the Mexican cession, which is Texas through California. That package of states, which was acquired in 1846. Who knows the Mexican cession off the top of their head, but mid 1840s. After Remember the Alamo and John Fremont in Sonoma, the mini Bear Flag Republic Revolution. Santa Anna surrendered his forces, and the U.S. acquired by cession, meaning they bought those 6 states there, plus a few more, plus Colorado and Utah. And under Spanish law, which were Mexican law, the former law, communities held property. So those states adopted that. They sort of grafted the old marital property law into their community, into their family law. Idaho, Wisconsin, and Washington are outliers. They were not part of the Mexican cession. Louisiana was part of the Louisiana Purchase, relying on French law. Again, similar history of community property. Now, why is that important? Why do I even bring that up? Because you'll see it shows up in Harmon. It shows up in the 1949 case. We're going to get to it a little bit in the Supreme Court case. It talks about traditional community property states. Let's go to the next slide. What has happened since the IRS, since Congress changed the rules to allow for a double step up in basis at the death of the first spouse? A rule that was motivated by allegedly trying to make it equal, because in common law jurisdictions, the husband tended to hold title to the property, and the husband 75% of the time died first, and so the wife would inherit everything with a step up in basis. And these community property states said, well, wait a minute, it's only a 50% step up. We need to be like the common law states. So they said, all right, fine. We'll give you a full step up in basis on community property, no matter who dies first. So no matter who dies first is the advantage that the community property states have on the stepped up basis. So thereafter, you have these 5 states, one at a time: Alaska first, then South Dakota, then Tennessee, then Kentucky, then Florida. Florida just this year, I think, all providing what are called opt-in community property rules, opt-in community property rules. So you can opt into a community property regime. Now, this is not how those states have historically characterized property between spouses. So why is that relevant? Because Harmon, a case we're going to talk about in a little bit, talks about, we're going to give advantage. It was an Oklahoma case. Oklahoma tried to jump on the bandwagon and say, we're going to have an opt-in community property statute. And we'll talk about that in a little bit. The Supreme Court drilled into the history of community property, which states have historically and why, and the Spanish, the Mexican Cession and all of that. So we'll get to that in a minute. The concept here, though, is that these states are trying to say that community property is available by the creation of a community property trust or a declaration of community property. Now, in Alaska, it's the creation of a community property trust, and that's what we're going to focus on here. And it's not only available to the residents of these 5 states, but in Alaska's case anyway, it's available to residents of any state. And it can be for some assets or all of the assets. So just like in California, in the regular community property states, you can draft what's called the community and separate property agreement. And you can pick and choose what you want community and what you want separate. Typically, because we often represent both husband and wife, we don't want to create a conflict of interest. So we preserve what is separate and what is community. If we do a transmutation to community, we keep an IOU in place. It's called Section 2640 of the California Family Code. It's an IOU back to the contributing spouse so that we don't create a problem in the event of a divorce and find ourselves a defendant in a lawsuit for malpractice for moving the wealthier spouse's assets to community. Next slide. Leonard, you want to talk a little bit about Alaska and where this came from?
Sure. As far as well, in meeting with my clients, we talk about what are the non-tax benefits for community property. Well, well, let me step back first to the tax benefits, because from my perspective, what we mostly do in my business and my discussions with my clients is mostly for tax planning for the use of the community property trust. And the reason for that, as Peter's already mentioned, is a double step up in basis upon the first spouse's death. So that's the primary reason of why we use community property trust in my practice. The non-tax benefits possibly is well, we use, let me step back, because Peter, I want to go off of what Peter talked about just a second ago as far as use of community property trusts and things in Alaska. And we'll talk about this on another slide just down later about electing into the regime or the community property regime here in the statutes and treatment in Alaska. we do it in two different ways. And as Peter said, we can preserve in Alaska, in our elect-in regime, the ability to keep separate property separate and to community property community. So these are discussions we have. Much like Peter, you want to be careful about what you're putting in and what you're electing in and what you're keeping and reserving, because of the issue of divorce comes up. It's a question that we have to address and discuss with clients, because some of the fear, being a separate property or common law property state in Alaska, the fear of some of our clients is, well, I've heard what happens on a divorce in community property states, and I don't want to do that. So it's just a discussion we have to have. But for our perspective, from my practice, what we do and my partners have been doing, it's almost 100% for tax benefits. That's why we utilize the community property system in Alaska. Otherwise, we can keep it the way it is. We don't use the elect-in.
Yeah, you got to have a stable marriage. The way divorce works, I mean, this is very generally, because you saw there are a number of states, and each state is a little bit different about how they do this, but they take half of the community property and give it to one spouse and half to the other spouse. And then the separate property of either spouse returns to that spouse. Now, there are all sorts of exceptions to that: dower and courtesy rights in common law states. We have probate allowances, family allowances, homestead allowances. We have protections for the poorer spouse sometimes. So it isn't, like, well, it's all his separate, she's out on the street. It's not quite like that. But it's going to vary from state to state. So when you're counseling clients about the non-tax benefits and, of course, the non-tax detriments, and divorce comes up, you're going to have to know your state law. The main non-tax benefit, Leonard, that I have run into is the ability of either spouse to manage the community, with the exception of real estate. But you can manage the real estate, you just can't convey it. So in the absence of even a power of attorney, let alone a community, let alone a conservatorship, the well spouse can manage all, or either spouse can manage all of the community property. So they go to the example I use with clients: you go to the grocery store and you pay for something. In California, they don't say, "Has your husband approved of this purchase?" No, either spouse can manage the whole of the community for the benefit of the community. And there are, of course, there's always a weird case out there where the husband goes off to Vegas and gambles the money away, and then that's a breach of fiduciary duty to the marriage under 721 of the Family Code, and so there's an IOU from the husband to the wife, et cetera, et cetera. Leaving aside that, basically either spouse can manage all of the community. So it's a simplified person. One spouse becomes incapacitated. Even in the absence of a power of attorney, the well spouse can continue to manage the community property.
There is, Peter, in Alaska law, there is some nuances there. Yes, the community spouse, either one can manage it, but if you're transferring it, and it depends on the type of property that's in the community, who can transfer it? Does it take one signature or both signatures? Yeah, there are some nuances there as well.
Yeah, I said except real estate. So conveyances of real estate require two signatures. We have in California, there's a procedure called the 3100 petition where you can do a one-off conservatorship. But conceptually, the idea is one spouse can manage all of the community. At death, if you have a joint community property trust, real easy to split it in half. You don't have to figure out what was his, what was hers, what belongs here. It's just like everything is theirs, divide by two, done. So you have some simplicity in the management of community property, aside from this double step up in basis concept. Next slide. Here it is. Heavy management responsibilities like real estate allows for the equal sharing of responsibilities, equal sharing of appreciation and income. Now, this is where we're kind of like touching Harmon a little bit. That income word we're going to get to in a little bit. The tax benefits, we've discussed the double step up in basis at the death of the first spouse. This is often this double step up in basis at the death of the first spouse. It's often a big motivator for the spouse that inherited, I have a case now, spouse that inherited 20 million from parents, grew that to 60 million. And I say, John, his name isn't John. I'm not going to reveal his name. I said, John, you know, if Mary predeceases you, that appreciation from 20 to 60 million, that $40 million is still going to be subject to capital gain at death. However, if you transmute that to community property and live a year, and it remains community property for a year, so 1014E, so there's another part of 1014 that says you can't do this on the deathbed. You know, you can't say, it's all community and then get a full step up. You gotta hang in there a year. Your basis in that 60 million is 60 million. And that's a motivator for him. And so the conversation then becomes, well, how strong is the marriage and what rights does she have? And, you know, can I get consideration for that? And we go down, you know, contracts to make a will. We go down various paths, irrevocable trusts, lats, et cetera, to try to see if there's a way for John to have his cake and eat it too. So understand it's a motivator for the wealthier spouse to transmute to community property, because if they survive, they get, especially with highly appreciated assets, they can liquidate everything and recognize no capital gain tax. Next slide. Here's a $10 million example. Fully depreciated real property. With no basis. Real property is always going to have some basis, right? Because the land is, you only depreciate the improvements. You can't depreciate land. So, but let's assume, how would it have no basis? How would land have no basis? Let's assume it's 10,050,000 and 50,000 was allocated to the land, 10 million to the improvements. What happens in a joint tenancy situation? Leonard, do you want to go through this at the death of the first spouse?
Sure. So in Alaska, if you don't elect in, because we're a non-community property state, if you just hold your property without electing into to community property, I go through this example with my clients every time in explaining the community property and the benefits for having it. What you have is, let's just say, and here the basis is $5 million. Let's say that the couple bought this property, and we're going to assume for the purposes of this example that the basis is $5 million. So each, in a separate property state like Alaska, each spouse has a $2.5 million basis in the property. And my classic example, as Peter mentioned, you know, historically the males seem to die first, and so I always kill off the husband first. So at the time and the property's worth 5. So at the time of the first spouse's death, let's just say it's worth 10. So what happens for capital gains taxation in a separate property state like Alaska? It is, you say, okay, the code says the spouse that dies gets a step up in basis of the fair market value on their half of the asset, or their half of the basis. So their half of their 10 million is 5 million, right? So the surviving spouse in a separate property state does not get that step up on basis unless they've elected into the community property statutes here. And so their basis remains at 2.5 million. So the basis then at the time of the first spouse's death is going to be 7.5 million. And you have a difference in capital gains between 10 and $7.5 million. So that's in essence, that's what you see in a separate property state like Alaska, unless you then elect into the community property regime.
All right, next slide. So you get a half a step up in basis, and this is kind of fun. You know, you do the quiz when your client's sitting there in the conference room, and you say, all right, now I'm going to give you door number 1, door number 2, door number 3, and you hold an asset as joint tenancy. Door number 1, there's no step up in basis. Door number 2, there's a half a step up in basis. And door number 3, there's a full step up in basis. Which one is it? And they kind of look at each other and they go, how the heck do we know? And then you say, well, it's a lawyer answer. It depends. It depends on whether it's community property or joint tenancy, even in California. If you have a written memorialization in a community property state, the Treasury regulations say it's community and you're door number 3. You get the full step up. Let's make a deal. You get door number 3. You never get door number 1. That's, the zebra or the giraffe. You remember, let's make a deal. Door number 2 you get if you've elected joint tenancy. So that's the concept. This is how you get to door number 3, is you create community property. Now, can you do this with a community property agreement? If you're in a community property state, the answer is yes. If you're in a separate property state, the answer is no. Well, the answer is we don't know. We don't know. It's riskier. We think the answer might likely be no. However, if it's a community property trust, as Alaska has, we think the answer is probably yes, although we're still waiting for that federal case to come popping out of the tax court on this point.
And so let me hop in here for a second, Peter, because for Alaska, for non-residents of Alaska, I mean, we're an elect-in, and we'll talk a little bit more about this later. If you are an Alaska resident, you can use a community property agreement. If you're a non-Alaska resident, the community property agreement is not available to a non-resident. You have to use the Alaska Community Property Trust, or else you can't elect into it.
Yeah.
And there are some other factors that you got to have, the trustee and assets, and we'll talk a little bit more about that. But just so that's one. And then the other thing, in talking with clients, since you don't have to have a community property agreement in Alaska, sometimes they say, oh, you're just trying to sell me a product. And I said, well, no, I'm not trying to sell you a product, because they say, well, if I keep this property until I die, the second spouse, then I get a step up at that time. I say, you're absolutely correct, you do. But in the meantime, if you have multiple pieces of property or other appreciable assets, you won't get the benefit on those unless you hold them. Yeah. If you sell them some other time, you still don't get that benefit.
And usually one spouse is the manager and the other one is the non-manager. And the non-manager doesn't want to manage property, so they want to liquidate. So you're basically saying to the non-managing spouse, you're going to liquidate and pay a tax. You want to liquidate and not pay a tax, you're going to need a community property agreement or a community property trust. In California, we can do a community property agreement. In Nevada, where I'm licensed, you can do a community property agreement or a community property trust. A lot of times we do both. We'll take a deed where, some escrow, they say, escrow agents and bank tellers are the most popular estate planners in the country. And that's probably true, because people say, well, how should I title it? The escrow agent says, I don't know, joint tenancy, or bank teller, I don't know, jointly. So what we do is we do double deeds in California. So there's a record. You don't need to do double deeds. You can have a written agreement memorializing it, which goes in your file. The problem is the client's 8 lawyers from now, and where's that community property agreement? And their file didn't travel with them because they were shopping lawyers the whole way. So it's kind of nice to do a deed from joint tenancy to community property. That goes to the county recorder. Anybody and everybody can see it. And then from community property to the trust. We call that the double deed solution. So it's just a way of making the record public and not wedding the client to your law firm for the rest of their lives. So you can show some impartiality. Next slide, please. Here it is. Leonard, take it away.
It's kind of I guess, a summary of what we've already discussed. So just quickly, as you see there, our act was passed in 1998. It is based on the Uniform Marital Property Act. And again, we have the opt-in election, as I just discussed. And the nice thing about it is you can opt into everything. You can opt into nothing by not doing it all, or you can opt into a partial thing. So you can select certain items or assets to be in your community property trust and either be community property or retain your separate property nature of it. And what that, as I talked about it, we can opt in. Alaska, people that are in Alaska, residents of Alaska, domiciled in Alaska, you can opt in through a community property agreement. It's called a community property agreement, or through a community property trust. I oftentimes, and my colleagues, my partners here, my firm, it depends on which one do you want to use, and it kind of depends on an individual basis what you're doing, what property you own, where you got it from, what you want to maintain in it, and how you want things to go upon death. Meaning, if you have it in a trust, one of the reasons for doing it, historically for doing a trust is avoid probate. I hear that all the time from clients. I had a friend, my uncle, my brother, they had a trust. My dad, it was great. It worked slick. I didn't have no probate. It was quick. Okay, that's one reason for doing trust. And again, if you have existing trusts that maybe you don't wish to revoke, you don't want to rewrite, you don't want to transfer all the properties from that trust into this other trust. If you're an Alaska resident, you can use a community property agreement and just designate everything as a community property.
Yeah, and in California, when we have clients with large amounts of separate property, or in Alaska, or in any common law state where you're setting up an Alaska community property trust, you may end up with 3 trusts. We used to end up with 5 trusts, but you may end up with 3 trusts: his separate, her separate, or spouse 1 separate, spouse 2 separate, and the joint community property. And you structure it so that his separate goes to his, starts out in his separate, so he can manage, amend it, modify it without her consent. She can do the same with hers. And then the joint requires a consent of both spouses or withdrawal of the community property. And then at the death of the first spouse, the joint splits into 2, and his half drops into his separate property trust, and her half drops into her separate property trust. She can still revoke, assuming she's a survivor, she can revoke, amend, modify, just like a regular old A trust in a community property state. So there's a 3 trust solution. I say there used to be a 5 trust solution, and that's before the Supreme Court recognized same-sex marriages. We would split it out into 5 trusts. So recognized for state law, recognized for federal law, recognized for both, recognized for state, recognized for. It was a nightmare. Now it's a lot easier since Obergefell. So we typically only have 3. Sometimes there'll be an islet, a slat, a slant, a dynasty, et cetera, the usual alphabet soup of irrevocable trusts. But in general, the revocable piece is structured into 3 trusts. So if you're in New Jersey and you're thinking about an Alaska Community Property Trust, understand you're still going to end up with 3 trusts. You're going to have a joint, a spouse 1 and a spouse 2 separate. Next slide. How do you qualify, Leonard? How do they do it?
Yes. In order to, again, as the slide just before said, if you're an out-of-state individual, you're not domiciled in the state of Alaska, you're going to have to, and you're a separate property state and you want to elect in and use Alaska community property laws, then you have to set up a trust. And there are requirements minimum requirements to be met for you to be able to do that. So Peter said New Jersey. So someone in New Jersey's there, they say, hey, I like this idea, community property. What do I have to have? Well, you have to have at least 1 trustee in Alaska that person is charged under Alaska law with the administration, and that administration of that property that you are putting into the trust has to happen in Alaska. And then you have to have some assets. Now, we don't have any kind of opinion that I'm aware of what the value is of the assets that are required to be here. That's an open question that hasn't been challenged or decided by our courts at this point. So the question becomes at some point, whoa, if I do that, I have a trustee in Alaska, what does that mean? Do I only have a trustee in Alaska? No, the Alaska Act allows you to have co-trustees, but at least one of them has to be in Alaska, a resident of Alaska, and with administration for the trust over those assets in Alaska.
Absolutely. And of course, Kodiak Trust, our sponsor of this slideshow, is
Yeah.
such a trustee. So, and they have both directed trustees and full service trusteeship. So directed trusteeship is where they're simply the administrative trustee. They're the address, the checking account goes there, and they're directed by an investment advisor and a investment advisor with respect to investments, and a distribution advisor with respect to distributions. Many trust companies, including Kodiak, don't mind being a directed trustee because they know if you're a directed trustee in 1,000 trusts, you're eventually going to be a full service trustee in many of those. Why? Because Junior is 16 and he has no idea about what modern portfolio theory is, or how to rebalance a portfolio, or how to manage money. And so they're going to typically defer to the trustee. The trustee is often the logical candidate for asset management. If you want Kodiak or any institutional trustee to be the distribution trustee, I strongly recommend you do a letter of wishes, and you give them as much guidance as possible. This idea of health, education, maintenance, or support in the discretion of the trustee. Trustees don't like that any more than beneficiaries like that, typically. I mean, there are exceptions always. But
Sorry, and I'm just building on that a little bit, Peter. I've had banks or trust companies, trust divisions within banks come back and say, Leonard, will you go out and file and ask for instructions or get from the court what our duties are, what we can do, because you have summary trusts that don't say enough. And so playing right on that point, these institutional trustees, they don't want to make a misstep. They want to do what's right, and they want to know what their duties and jobs are.
Letter of wishes. What are the values of the family? Is it a family of doctors? A family of doctors? I assure you, the letter of wishes always includes the cost of medical school in the permitted distributions. And similarly with a family of lawyers. Startup entrepreneurs often say, yeah, let them have a certain amount of money to start their first business. And then there's this whole family bank concept when you get into family office, where it's just money. Allow the beneficiary to take a loan at the AFR, the lowest applicable federal rate, to conduct their own investments, and use a committee of trusted people, whether it be the CPA, other family members, what have you, to make decisions just as a bank would make a decision with regard to the distributions to those beneficiaries. I had a client go through and talk about bar mitzvahs and bat mitzvahs and how much they would, and weddings and so on, and he had some great language in there, like, I'm talking about a $75,000 wedding, not a $700,000 wedding. Yeah, just so the trustee would have some feel for, what they meant. And this was a several $100 million estate. So it was possible that the daughter could think, oh yeah, I'm going to have $1 million wedding. No, he was like, I was against that. Bar mitzvah, bat mitzvah. Keep it around $30,000, or index it for inflation, etc. So really, really good guidance for the trustee, really good guidance. International travel, emergency health. What about cosmetic health? You say health, what does that mean? Can she get a nose job? Can she have a facelift? Can she get a boob job? Does he get a personal trainer? On and on. The more detail, and this is where you as lawyers really make your money. You have to counsel the clients through these issues, because you want to look at cases. Look at the California appellate distributions from about 1949 to 1964. The California appellate law is full of arguments about what's health, education, maintenance, or support. Next page. All right, here we go. Federal tax issues. We have no court cases since the adoption of the act. We had one court case before the act called Harmon, Commissioner of Internal Revenue Service versus Harmon. Now, Harmon's a weird case because, as I alluded to before, it came out of Oklahoma. Oklahoma said, we like this community property stuff. And in the 40s, there were these bracket run-ups that were very different than they are today, where now married filing jointly, you have a very similar bracket structure until you get over 500,000. There's places where there's a mismatch, but this was in an era where the husband had the idea that if he did a transmutation to community property and they filed separate returns, the wife would get the bracket run-up, right? So she'd be able to pay, overall, the family would be able to pay lower tax. And the Fifth Circuit liked it, but the Supreme Court didn't. A different Justice Roberts than the current one we have concluded that, and this is where he went into the history. Oklahoma doesn't have this lengthy history of Mexican cession and community property, and so therefore they disallowed it. But they disallowed it on the understand that's an income tax case involving married filing separately. So today, married filing jointly, there'd be no issue because both spouses' income are on the same return. So there'd be no reason for this case to even exist. So you're only going to have to think about harm. Well, I shouldn't say you're only going to have to think about it, but you're going to have to think about Harmon if one of the goals of the New Jersey client is to income split and do married filing separately and have the poorer spouse run up the bracket. Harmon's not going to let you do that, even within that was a community property agreement. So would they allow you to do it with a community property trust with respect to the income of the trust? Maybe. We just don't have the answer on that. So I want to distinguish Harmon on the basis it's an income tax case, totally different era where there were, bracket run-ups of married filing separately. And so a different set of facts went into it. We have had some guidance from the Internal Revenue Service since then. You want to talk about the Alaska court cases, Leonard?
Sure. So this Phillips versus Bremer Phillips, as you see, it's a divorce case. The issue there was the husband had separate property. He had rentals. He had a fourplex and he had some other rentals next to, it's a mobile home, next to, or mobile home park, next to his fourplex. And they lived together for a while. Then they finally got married, and then they did a community property trust and transferred their separate property. The husband did transfer his property into this community property trust. And the question at trial was a couple. First of all, did transferring that separate property that he had into the community property trust transmute it, convert it into community property? And one of the other issues that came up is there was appreciation and income off of that property. And was that community property or was it non-community property as far as for issues of divorce law here in Alaska? Essentially what the Superior Court, the lower court did, and which was approved by the Supreme Court of Alaska, it said that putting separate property into a community property and saying that everything in that community property trust is community property without reserving some designation of separate property, it is community property. And so for purposes of divorce on that case, we're going to treat it as it was equally owned. It's equally available to be divided up how we deem equitable in the court of law in the divorce. The second major issue there was, there's rents coming in off of this mobile home park. What happens to those rents? Are those community property and the appreciation of value? Is that community property or is it separate property because the property itself is in the community property trust? They transferred in there and said it's community property. And that, the Supreme Court parsed around that quite a bit and looked at legislative history and finally agreed with the lower court saying that as to if you want to transmute income and appreciation in a community property trust, you've got to say it. And if you don't say it, it isn't. And so in this case, they said it is not. However, the husband took those funds and dumped it into a community property bank account, so it didn't matter. In the end, the income became the income, it became divisible. But going forward, after the filing for divorce, it was separate property.
Yeah. So each state is going to be different here. Texas, for example, the income from, I think the income from separate property is community. And in California, the income from separate property is separate, unless you say otherwise. So each community property state has a different treatment of community and separate. And so know your state. The result would be very similar in California. We have a statute, by the way, Leonard, Family Code Section 2640 says the contribution by the spouse of their separate property to the acquisition of a community property asset, it transmutes it to community property, but it creates a reimbursement right without interest back to the contributing spouse. So husband contributes $100,000. They buy a fourplex. Let's say it's worth $1.1 million when they buy it. They borrow $1 million. They pay off $1 million. He transmutes it to community. It increases in value to $2.1 million. Just doing that so I could do the math in my head. So you have $1 million capital gain. The husband has an IOU of $100,000 back from his original contribution under 2640 of the Family Code. And then they split the $2 million, 50-50. Now you can waive the right of contribution. Now that I would call a post-nuptial agreement. And I would suggest, although I don't have any law on this, that if you intend to waive the reimbursement right, each party be represented by separate counsel. I think that if you're preserving the reimbursement right in the event, and it's only in the event of divorce, I think you can do that as, with a waiver of conflict of interest after encouraging the parties to get separate counsel. And you can be the lawyer for both spouses in that circumstance. I'm not aware of a case where a lawyer got sued for a transmutation preserving the 2640 reimbursement right, just as an FYI. Next slide. So if you're in New Jersey and you're, unequal contributions, make sure you spell out what happens in the event of divorce. Is there a reimbursement right? And then the more of a reimbursement right, the less community it looks. So be aware of that too.
Right. And I think that works here in Alaska too, because it's where they elect in, and whatever you elect in and what parameters you put on that, I think is going to be respected in the trust.
Yeah. So further discussion here, we've included some secondary sources from the first 5-10 years that the Alaska community property opt-in regime was enacted. On the next slide, let's go to the next slide. We actually talk about some of the IRS promulgations. So now there's a risk. So let's say you're jumping in, you're going to do this. You've got the client who's perfect for this. Wife has a spot on the X-ray. All assets are in the name of husband. The idea is to transmute it to community because there's a highly appreciated asset husband wants to liquidate. Or husband has a spot on the X-ray and wife has the inherited money and wants to add husband. Now, there are all sorts of things you can, leaving aside inter vivos, Q-tip, and all these other crazy things. Can you just do a community property trust here? So if you do so, you want to read these three authorities, these three publications. Well, publication 555 is a non-authority because it says expressly in the beginning, and it describes how you treat community property for income tax purposes. And it expressly says it doesn't consider the federal tax treatment of income or property subject to the opt-in. I missed the keywords, the opt-in community property states of Alaska. And at the time this was drafted, I think it was just South Dakota, and now it's Kentucky, Tennessee, and Florida. But take a look at these. Now Leonard likes 8798, which I think is good, and I agree with him, because although Washington is a community property state, it does say, the character of property is a state law issue and binding on the IRS. Okay, so they're in the state of Washington. They agree in writing that presently owned property and property acquired thereafter will be community property. It changes everything. And even if they go to a common law state, and you'll see here, if property held in a common law estate is community property under state law, it is community property for purposes of 1014B6, regardless of the form in which title was taken. So how could it be community property in a common law state? Well, there's this Uniform Act. Do we have a slide on that, Leonard?
I don't remember if we did have that.
Okay, so it's called, and if you you have a pen, write this down, the Uniform Disposition of Community Property on Death Act. That's a mouthful. The Uniform Disposition of Community Property on Death Act. And there are a number of common law states, Oregon, I'm not sure how many, roughly 15, I think, maybe 10, maybe 20, that are common law states that have adopted this. And they say, we're going to characterize, you moved from California, you had community property, you entered into a community property agreement there, you came over here to, Colorado, and you memorialized your community property with this after acquired forever. I love you, honey. It's all community. There's no such thing as his and hers. It's all ours. This is a great revenue ruling for you. And so can we lever? And I wouldn't ask the question if I didn't think it was relevant to this presentation. Can we lever this revenue ruling to say, well, now, wait a minute. Alaska has an opt-in statute. Under state law, New Jersey is required to honor, under the full faith and credit clause of the U.S. Constitution, the Alaska character of the asset held in a community property trust. And so even though it's held in a common law state, New Jersey, arguably the IRS has to honor the state law, the Alaska community property law, under the full faith and credit clause in New Jersey. Now, would this apply to real estate? Leonard, what are your thoughts? New Jersey real estate, and they're going to put it in Alaska Community Property Trust. What do you think?
Well, certainly the argument's going to be by putting it in the community property trust, you elected to use that designation. And will it work? I don't think any of us know 100% because I don't know of a case that's out there that talks about it. Do we do it? Yeah, we do it. We do it all the time in my practice. If I have a client who's now, do I do it for out-of-state people that don't have a nexus to Alaska? I haven't done it in that context, but I do it all the time right now with folks that are domiciled in the state of Alaska and have real estate in another state. That's the only nuance different from your example, Peter, is you're dealing with people that are in Alaska versus out of Alaska.
Yeah.
But you're still treating it the same. And then, I guess we can mention that law review article that you maybe, I don't know whether that made it in the slides.
The Nevada Law Journal. If you're going down this path and you have a very substantial client and you really want to understand this, Jeremy T. Ware, W-A-R-E, wrote a law review article. Unfortunately, it was in 2005, but it's a very good article in analyzing the different moves of community to separate property, separate to community, one community to another community. And then lastly, he talks about Alaska. And it's called Section 1014B6 and the boundaries of community property. And it is Nevada Law Journal, spring 2005. I don't have the volume, unfortunately, but it's 2005.
Volume, it says volume 5.704.
And yeah, it's on page 704.
Yeah.
Really good article that analyzes all the constitutional issues that are posed by this. And another thing Leonard and I have talked about, like, you know, you got a big case. You got a case where you have real concerns that the law of the situs, the real estate in New Jersey is going to go, you know, the conflict of laws that we all took in law school. It's the law of the situs, and real estate is always situs in the state where it is because you can't move real estate. Could you, instead of just setting a community property trust for that real estate, Alaska Community Property Trust for that real estate, set up an LLC, maybe an Alaska LLC, that holds the New Jersey real estate and the membership interests to the Alaska LLC, which are intangible personal property and therefore governed by the state of situs. And if the trustee is in Alaska, there's situs in Alaska. Can you use that? Is that a safer approach if you have this highly appreciated real estate that you want to do? And I think the answer is it's safer. We don't know still, but you know, if you're looking for safety, there may be options there.
You know, that we certainly talked about that. And I've talked about that with my colleagues. That's been a discussion amongst my colleagues here in Alaska. And it's an interesting thought. I don't know of anyone that has done that yet, but it's under consideration.
And then clearly the membership interests of the Alaska LLC would be situs in Alaska.
Correct, right.
So there's your situs argument. All right, next slide. Do we have a next slide? There it is. Your candidates. So they got to be in a long-term stable marriage. You don't transmute huge amounts of money and then they get divorced. Highly appreciated assets because we're really doing it for the step up in basis. Own a family business that will be sold at death of a spouse, and that's because the survivor just doesn't want to run the business. And I've got clients who do, you know, the real property management. This is a common one. You know, one spouse is the broker that's wheeling and dealing, and the other spouse is passive. That's a great candidate for a community property trust. Do they live in a non-community property state? Would you do this in California? Would you set up an Alaska one? Here's where I would do it. I would do it if they're moving to a common law state because California doesn't have an opt-in provision. Now, we do have that revenue ruling from 1987, which Leonard so graciously provided to me about Washington State. But you could button that down with an Alaska Community Property Trust before they move to Colorado, before they move to Oklahoma, before they move to Massachusetts. Who would move to Massachusetts from California? Before they move to Florida.
And then you have the additional argument. If they're moving from a community property state, it's already community property, dumping it into a community property trust. I don't think you run into that same problem as it's New Jersey property, that's separate property.
While they are residents of California,
Correct.
get the community property agreement done, follow that revenue ruling from 1987, get it done while they're residents. Buy the home in Colorado or Tennessee or
Right.
Massachusetts, Florida. Buy the home while they're still a resident here. Don't move there. Oh, and then we're going to look around and they're residents of Florida already, and then they buy a home there. You've created more risk than you need to. Stay a resident of California, visit Florida, come back to California, visit Florida, sell your house here, buy the residence in Florida, then move to the residence in Florida and change your residence after you bought the home. Next slide. Tax benefits are huge. We have beat that. What's the cost? The drafting of the trust? Oh God, who knows? You know.
Yeah, that's really client specific. It's really hard depending on what they own and how much they're having you do.
Yeah, I'm glad we just put a dollar figure there. So in the 3 trust solution, separate, you know, spouse 1 separate, spouse 2 separate, joint, pour over wills, blah, blah, blah. I don't know. It's $6,000 to $8,000 for your basic middle class estate, right? Maybe a little bit more because you've got this Alaska wrinkle. Here in California and Nevada, I usually just draft them as a residence of the state. So it's $6,000 to $8,000 for middle class. Oftentimes I'm hired to do, you know, irrevocable trust planning as well. And that's 20, 30, 40,000 for slats and slants and grats and so on. Clats. I do want to bring up there's some loss of creditor protection of the non-tortfeasor spouse. So wife smashes into a school bus. There's not enough liability insurance to cover the lawsuits that are going to come out of that. All of the community property is susceptible to the judgments of the plaintiffs as creditors. Husband's separate property prior to the transmutation would not have been accessible to the creditors of the tortfeasor spouse. Once you do a transmutation to community property, you are losing a little bit of creditor protection. The solution there is umbrella insurance. Get 5 million, get 10 million. It's actually cheaper than the annual fee to the trustee. Next slide. Questions. All right. Let me see if I have my chat box here.
And I'll just, before we hit there, Peter, you know, the annual fee to the trustee, the benefits of the community property trust and using it here in Alaska, I think is well worth the hiring of a trustee that knows what they're doing. And, you know, if you have any questions, certainly contact Kodiak Trust Company. They've got people that can talk with you and figure out what you own and what you have and what it may cost for them to run that on an annual basis. So yeah. I wouldn't just say, oh my gosh, that's a lot of money. Even if you were doing a non-community property trust and you have a professional trustee, you're going to pay some percentage of the first whatever amount it is, you know. And typically here in Alaska, first $1 million or anywhere between $1 million, 1 and 1.5% under management and just a regular flat old trust. So you get what you pay for, and sometimes you lose too if you don't do it.
Yeah, and understand that an institutional trustee is less likely to be second guessed by the internecine rivalries that have fomented over the 50-year lifetimes of the siblings who are going to inherit this. And so in using an institutional trustee, whether for investment or distribution, you know, and during life, mom and dad can invest and distribute, you know, they can be their own, it's revocable. But at death, and they really wanted, you know, John, who got the MBA at Wharton, to be the trustee, but John and Greg don't get along. And so now they're concerned that Greg is going to be miffed if John, you just pull yourself out of there. You just allow John maybe the opportunity to make recommendations about the investment advisor, and then give Greg another responsibility and put a referee in the middle of that boxing match so they don't bludgeon each other into a bloody mess. Do you see any questions? I don't have a chat box here. Josh?
I don't see any questions, and it looks like we don't have any hands raised. So we'll go ahead and close. Peter and Leonard, thank you so much for a wonderful presentation. Very interesting topics, and we're really grateful for you for your expertise. If anyone has any questions following the presentation, if you are watching this after today, feel free to reach out to us here at Kodiak. And once again, Peter and Leonard, thanks so much, and I hope you have a good rest of your day.
Thank you, Josh. You guys take care.
Yeah, thank you. Take care.
Bye.